mention the general political instability in the country. We should mention the annexation of the Crimea. We should mention the military conflict in the eastern Ukraine. We should mention also the migration of the population in emergency. And in the light of all that, we observe the enhanced activity of the law enforcement authorities. We are aware of the situation when some companies, local and international companies, including pharmaceutical companies, were receiving different requests from the law enforcement authorities, to provide different information, and we know even the situation when the searches were conducted in the facilities of some companies. So among the economic grounds, of course, we need to point out the inflationary pace. We need to mention the currency devaluation over 100%. We also need to point out that the business in general is the activity of the business in general decreased, and there are many other grounds. Among the regulatory grounds, I would mention that we do not see any significant reforms in the healthcare system as for now. Of course, there are some changes, but we cannot call them reforms. And we don't see even the explicit concept of the reforms. So, of course, this is this influence on the market, and we think that if the situation continues like that, and at least up to the end of the year, we will see that the purchasing capacity of the population is dropping down significantly, and we will see that population will try to choose cheaper local pharmaceutical products instead of more expensive imported products. But in my opinion, the situation may change rapidly if the at least active phase of the military conflict in the eastern Ukraine will be seized, because we can see the efforts of the authorities to resolve the situation. We see this dialogue between business and the authorities. So this is the general situation on the market, general trends. But right now, let's just to give you a picture of what is going on in Ukraine. Now let's move to the legislation, to the changes in the legislation, and we will start with the competition. Despite there were no significant changes in the competition legislation for a while already. It was and remains a very hot topic because of the active position of the Anti-Monopoly Committee of Ukraine. The Anti-Monopoly Committee of Ukraine pays very serious attention towards the pharmaceutical market, special attention of the Anti-Monopoly Committee of Ukraine were the contractual relations between the manufacturer and distributor, between on the one hand, and the manufacturer and pharmacies or chain of pharmacies on the other hand. So you are probably, I'm sure you know that many pharmaceutical companies were receiving different requests from the committee and provided different information, including the copies of the contracts, etc. The committee performed the analysis, and they identified several common violations of the legislation. We tried to put those violations in the opinion of the committee on this slide. This is in the context of the relations between the manufacturer and distributor. One of the common violation in the opinion of the committee is that the contracts contain the provisions which oblige distributor to provide different kinds of reports, information regarding the further sales of the products, like the specific location, the specific purchaser, quantity of the products, even the activity of the competitors, and etc. In the opinion of the Anti-Monopoly Committee, this is an attempt to control the market and restrict the competition on the market, and that's why they consider it as not compliant with the current legislation of Ukraine. The other hot topic is discounts and bonuses which are provided to distributors. In the opinion of the Anti-Monopoly Committee, the discounts and bonuses are often provided not for some kind of achievements on the part of distributors, but for mere implementation of the provisions of the contracts. Just give you an example. For example, the contract may contain one provision which would say that the distributor is supposed to provide a 100% prepayment, or make a 100% prepayment. The other provision in the same contract may say that if the distributor makes a 100% prepayment, then such distributor is entitled to the discounts or bonuses, but this is not some kind of achievement on the part of distributor. This is just simple implementation or performance of the obligations under the contract. The other provision which attracted attention on the part of the committee is that the contracts is that the manufacturer sometimes try to have the provisions which give the manufacturer the right to provide different kinds of recommendations regarding the price for the further sale of medicinal products, or the recommendations or even restrictions regarding the further purchasers of the products. For example, the contract may contain the provision which would say that the distributor is entitled to sell the products only to the legal entities which have certain number of pharmacies, or that the distributor is not allowed to export the medicinal products, etc. All those, in the opinion of the Anti-Monopoly Committee, lead to the control of the market, restriction of the market, and even increase of the unjustified increase of the products, prices for the products. Now let's move to the contracts with the between manufacturers and pharmacy chains. Here, the Anti-Monopoly Committee focus on special services which, in their opinion, serve as an instrument to for the market allocation or control of the market again. This is the services on ensuring the maintenance of the sufficient product stock level. Here I mean that such here we're talking about the particular assortment of the products which are purchased from the particular distributors. And the other interesting service is on ensuring the sufficient remnants of particular medicinal products. Of course, the pharmacies are interested in having such contracts with the manufacturers, and they are interested in providing such services if they are receiving the compensation for that. But in the opinion of the Anti-Monopoly Committee of Ukraine, this basically may lead to the situation when the pharmacy will be interested in selling more products of the particular manufacturer instead of the other manufacturers. And again, it will lead to the control of the market or restriction of the market. The committee also finds some services very suspicious. For example, such service as possibility for the medical representatives of the company or representative office to visit the pharmacy. So what is so special about it? Why do the pharmacy have to receive compensation for this? Or another example, or another example of the service is when to conduct presentations for employees of the pharmacy chain. Again, why do the pharmacy have to receive compensation for this? Because basically the representatives of the company provide the service, but still under the contract, pharmacy chain receive payments for that. So in the light of all that, our recommendations, we recommend to have these kinds of contracts with distributors and pharmacy chains be reviewed by internal lawyers or external lawyers, and of course these suspicious provisions shall be excluded from these contracts, or at least modified. We know the situations when when it is crucial for the manufacturer to keep specific provision in the contract, but the provision may be not, may be ambiguous and may have some risk, but it doesn't directly contradict the Ukrainian legislation. In this case, we would strongly recommend to address the committee and request the clarification on this, just to make sure that that such provision is compliant with the legislation. All right, we'll try to move forward as we do have a lot of information, so that we would stay with the time limits. And now I suggest we go to the anti-corruption legislation. As you know, in April this year, a new law of Ukraine on prevention of corruption became effective. The law introduces several new terms. In general, the law contains, I would say, many different changes. And we will look at some key changes, within this presentation. But if you have any specific question, you can always write us, and we will be pleased to answer your questions. So the law also contains different limitations related to gifts. I mean, the value limitations. It establishes mandatory requirements for legal entities which were not which the previous law didn't have. And this law establishes some increased sanctions within administrative liability. On this slide, in the right column, you can in red you can see those new terms which I just mentioned. This is offense related to corruption. This is gift. This is a real conflict of interest and potential conflict of interest, instead just conflict of interest. So what is the difference between corruption offense and offense related to corruption? Offense related to corruption means actions that do not exhibit signs of corruption. However, such actions still violate the requirements of the law and some kind of liability maybe and in result some kind of liability is stipulated by the law for such actions. While the corruption offense means the actions exhibiting signs of corruption. So that's the main change. The term illegal benefit, this term was in the previous law. It was added with some additional benefits. You can see those in red. And it means just different kinds of benefits promised, offered, given, or received unlawfully. Instead, gift stands for those benefits which are provided and received free of charge, or at a price lower than the average market price. Another change is, as I have already mentioned, is the value limits for the gifts. As you can see on this slide, earlier we had the maximum value of the gift for one time was 50% of the minimum salary, which is about 600 hryvnia or so, and now it's one minimum salary, which is about 1,200 hryvnia. And then the total value of gifts received from one source within the year was one minimum salary. This is 1,200 hryvnia, and now it's about 2,400 hryvnia. So just doubled basically. Another change or another amendment is related to the additional obligations for the legal entities. Now the law requires that legal entities would perform the regular assessment of corruption risks and implement different anti-corruption measures. We noticed that some requests from the law enforcement authorities like police or the state security service included the questions whether the legal entity performed different due diligence reviews of their potential contracting parties or so. Of course, such questions, in my opinion, are not justified because the earlier legislation of Ukraine didn't require the legal entities to perform such reviews. And even this current law, it doesn't provide any specifics. Yes, it says that the legal entities shall perform regular assessment of corruption risks, perform some kind of audits, and so on, but it doesn't explain what expressly, what it means. In my opinion, introduction of elaboration and introduction of some kind of due diligence procedure and implementation of due diligence reviews would demonstrate that the legal entity makes everything to ensure that to prevent the corruption risks. The law also envisages different requirements for officers and staff of the legal entities. Those requirements, in my opinion, are pretty obvious, and I don't think we really need to spend time on those. It just like not to commit a corruption offense or not to be engaged in a corruption offense. But what I should draw your attention to is that the employees of the legal entities shall inform about the any corruption offense or even incitement to commit a corruption offense or so. Another interesting amendment is related to anti-corruption program. The law establishes that legal entities have need to have some kind of anti-corruption procedure in order to prevent corruption actions, different corruption actions. But I should mention that such anti-corruption procedure is obligatory or mandatory for in two specific cases. The first case, this is when the legal entity takes part in the public procurements. I assume that in this case the legal entity will have to provide some kind of confirmation that it has the anti-corruption procedure. It may provide maybe a copy of the anti-corruption procedure, or in some other way inform about that it has the anti-corruption procedure. It all depends on the exact requirements of the documentation, of the tender documentation. The other again, here I would like to add that such anti-corruption procedures, you know, all employees of the legal entities shall get familiarized with such anti-corruption procedure, and it shall be documented somehow, maybe you know, by way of signing some kind of document that the employees have read, understand, and agreed to comply with the requirements of the anti-corruption procedure. The law even establishes the scope of the anti-corruption procedure, what it should include, but it has only a but it's not obligatory. It's you know, it's not, the law doesn't say that it has to be this way only, so it's more like a recommendation. In the other situation, when the anti-corruption procedure is obligatory, is it is obligatory for state and municipal entities who have certain number of employees within the fiscal year, financial year. This is not less than 50 persons, and the certain level of gross revenue. As you can see on the slide, this is not less than 70 million hryvnia, Ukrainian currency. The law also envisaged that the legal entities need to appoint an authorized person, a compliance officer. And there is an interesting situation here because there is no the law doesn't envisage the way who and how and in what cases it may be checked whether the legal entity has an authorized person or compliance officer at the company or not. The only case is when, as I mentioned earlier, for the public procurements, the legal entity may need to confirm that it has such person on a staff. But anyway, the law has such requirement, and the law also establishes the specific requirements to such person. You can see it in the second part of the slide. I think naturally we move forward to the public procurements, and this is also a very special sphere. I would say it is in Ukraine. It is often associated with frequent changes, like every second or third year we have a new law on public procurements, and a lot of changes are introduced into the law during the year or so. And another thing is that the public procurements are often associated with corruption. So some changes were introduced into the law, which envisaged that some specialized international organizations may perform such purchases for the Ministry of Healthcare. You know, different experts in the public procurement sphere have different opinions regarding this amendment, because not all experts believe that such amendment may work for many reasons. But you know, it is hard to comment on this at this point. You know, I need to say that a lot of some sub-legislative acts need to be adopted in order so that that amendment would work. It is important to identify the list of medicinal products and medical devices which can be purchased through such procedures. It is important to identify the procedures of supply of products and etc. The work is being actively performed on this, and we know we saw even the drafts of some of those documents. But let's see how it works, and let's see if it will be implemented. Price regulation. I think we will need to move a little bit faster because we're running out of time. But here we have some fresh-made changes. Just a couple of weeks ago, some changes were adopted or became effective in this area. As you remember earlier, when we had to declare the wholesale prices for medicinal products and for medicinal product, we had to compare the reference prices in the other countries. So this requirement was canceled, and so now we basically take the contract price and multiply it by the rate of hryvnia under the National Bank of Ukraine, and that's it. Timelines, as you can see on this slide, the timelines for declarations also were changed. Earlier, for medicinal products, we had 22 business days, and for medical devices we had 12 business days. Now it's 12 business days. Well, it's 10 business days for considering the documents and making the decision, and 2 days for publishing the information on the website. So in general, it's 12 days for medicinal products and medical devices. Another thing is that earlier we had the limitation with regard to the quantity of, with regard to how many times per month we can declare the wholesale prices. And it was just once per month, but now there's no such limitation anymore. The Ministry of Healthcare of Ukraine is also entitled with some additional rights to correct the wholesale price of the products. If the average monthly rate of hryvnia to US dollar changes for more than 5%, you may ask a natural question: what happens if the contract is in euro, for example? There's no problem with that because the prices are registered in hryvnia anyway, so they can easily make those calculations. Since we do not use anymore the reference prices, the state price inspection, well, there's no need in a state price inspection anymore. So this provision was cancelled. And the general list of documents which is provided, which is submitted now for the declaration of medicinal products and medical devices is significantly simplified. Now you can see that for medicinal products we shall submit only the application and power of attorney. And for medical devices, application, power of attorney, copy of the registration certificate. I should mention that at this point the declaration of wholesale prices is not performed. Only it may be performed only in some exceptional cases. Why? Because the ministry needs to develop and approve all those new applications, and usually it takes about 2 or 3 weeks for this. Let's move further and talk about the determination of markups. As you can see on this slide, that there is no change in the wholesale business in terms of the markups. It's still the same maximum 10% markup. However, the retail markups now shall not exceed 25% of the purchasing price, and there is no differentiation with regard to the product cost as it was earlier. Advertising of medicines. Right from the very outset, I would like to say that there were no significant changes in this area for the last half a year or so. However, I should probably mention that the Parliament coalition raised the question last year regarding the possibility of introduction the total ban for advertising of medicinal products. In my opinion, it will not happen soon in the nearest future, if ever. So what else? we probably need to mention the changes to the law of Ukraine on advertising, which took place last year, in the middle of the last year. This is this new law have introduced a new term, TV sales, which means direct public offer to conclude a sales contract for certain goods. However, I need to say that TV sales of medicines, of medicinal products, and medical equipment in general are forbidden. Besides, this new law envisages that manufacturers and sellers of medicines and medical equipment may sponsor TV programs and radio programs, by way of advertising information about the name and title and trademark for goods and services. However, in this case, we need to say that there shall be no reference to the medicines which are sold under prescription and medical equipment which requires a special, the use of which requires a special training and knowledge. Pharmaceutical market regulations. We have several changes in this area, and as you can see, at the end of the last year was very fruitful for changes, and in the regulatory sphere as well. As you can see now, as you can see on this slide, now the re-registration of the medicinal products is not required if the product is registered, and the registration, if the product was registered and then re-registered, then any further re-registration of that product is not required. Such re-registration will or is valid for unlimited period. So which is very good. As you remember earlier, we had to have the products re-registered in every 5 years. Another interesting change is that if the medicinal product was issued into the turnover on the market, and the registration certificate expired, but the product still may be sold on the market until its expiry date on the package. I think I need to show this picture just to illustrate what I really mean. You can see the date. This is when the law became effective. So the first vertical line demonstrates the situation when the product will not be able, when we cannot sell the products after the termination of registration certificate. So let's look at this picture. Here you can see that first the customs clearance was performed, then the certificate of quality was obtained, and then termination of registration certificate occurred. Then we have the date, and all of those happened before the law became effective. So because of the retroactivity of the law is not allowed, the sale of such products after the termination of the registration certificate is not allowed. On the picture below, you can see that first the law became effective, and then after that the custom clearance was performed and certificate of quality was obtained, and then termination of the registration certificate occurred. Then in this case the product may still be sold until on the market until the expiry date on the package. Hopefully it is clear. If not, please write your questions and we will try to explain that. Let's move further. Oops. Some other changes were introduced to Article 9 of the law of Ukraine on medicinal products. As such, changes envisage simplification of the procedure of registration of medicinal products for some specific diseases. You can see those diseases on your slide, provided such products are registered in EU, USA, Switzerland, Japan, Australia, and Canada. So what I mean by the simplification of registration procedure, there are less requirements for documents. I will not read those. You can read those on the slide. The GMP copy is not required, provided the manufacturer may guarantee that such medicinal product for Ukraine will be produced at the same facilities. And the last thing is the timelines. As you can see that for the registration is performed within 7 days instead of 1 month as it was earlier. Some simplification, some simplified registration procedure is introduced for original medicinal products which are registered by the European Medicines Agency. And for the time's sake, I will not go into the details what documents, etc., what will be examined. You can see it on the slide. Also, it shall be mentioned that after the registration of the medicinal product, the components of the medicinal product in bulk and active pharmaceutical ingredient are automatically prolonged as well. Clinical trials. Just a few words in this section. Here we have the requirement that the agreement on life insurance and health of the patient shall be concluded prior to the clinical trials. It may sound a little bit different from the common practice when the insurance contract of sponsor's liability is concluded. But that's the Ukrainian requirement. Besides some technical changes, the new templates of the documents are adopted, so please pay attention to that. And again, some timelines. You can see that the general timelines were decreased, some insignificantly. For example, term of examination of an application on trial was 50 days, and now it's 47 days, so it's basically only 3 days. But in some cases, it's almost a month. For example, at the bottom of the slide, you can see that the term of consideration of application to review a refusal of the Ministry of Healthcare to start trials was 60 calendar days, and now it's 30 calendar days. So that's a significant change in terms of the timelines. Quality control. Another amendment was introduced to the resolution of the Cabinet Ministers of Ukraine number 902, again at the end of the last year. And this amendment envisages that national manufacturers are entitled to conduct their own quality control of products in bulk. And but there, provided certain conditions are adhered, and you can see those on the slide. This is obtaining the status of the resident. This is having the certified laboratory, or the manufacturer should have a contractual relationship with such laboratory, and so on, and so on. Also, I think we have run out of time. I will take a few more minutes of your time. Please look at this slide. Starting from February this year, licensing on import of active pharmaceutical ingredients have been cancelled. That's another interesting change. I have a couple of slides also on the law of Ukraine, on the draft law of Ukraine medicinal products. Our company was working on it. The main goal was to make the Ukrainian legislation closer or in line with the European legislation. But for the time's sake, I will not stop on this. If you have any questions, you can contact us, and we will provide you with the detailed information on that draft law. But I need to say that many moments which were envisaged by the draft law have already been introduced by way of introducing changes to the current legislative acts. For example, timeless re-registration of the medicinal products. So to summarize this webinar, I would like to say that we all believe that the military conflict in the eastern Ukraine, at least the active phase of the conflict, will be ceased soon, and the economic collapse of Ukraine will be stopped. This will, I believe that in this way, the the purchasing capacity of the population will finally be restored, and the patients will be able to choose between among the products, medicinal products they want to purchase without not trying to spend less time and spending less money on the products, and the main focus of such purchases will be the quality. In terms of the legislation, I need to say that we observe gradual implementation of EU legislation in Ukraine, and we see, as I have already mentioned, we see this dialogue between business and authorities, and we see serious and sincere efforts to resolve many problems in this area. So despite all of these efforts, I think our country is at some kind of turning point and in the history, and we still observe that there's no very good coordination between the bodies of the state authorities with regard to making the specific regulations. Thank you for your attention, and I'm sorry I took more of your time than it was planned. At the end, I would like to draw your attention that we could not go into the details within this short webinar, and we tried to focus on the key aspects, key changes in the legislation, and demonstrate the main tendencies on the market. However, if you're interested in receiving a detailed report on the changes in the legislation, etc., you can contact us, and you can write to. Oh, I'm sorry. You can write to my email, and you will see it in a second. And the last website and the last page, you can write to my email address, and if you're interested in receiving it. The participants of this webinar and our clients will be entitled to 25% discount. Thank you very much for your attention.